lot of times, and I always say this to people, when you buy a property, you buy a picture. You go in and you see this pretty, and that's what you buy. And that's why when you move in there, you look and you go, but I didn't see the damp there. Or today we're talking property transfer, and we are talking to our subject matter experts, Grant and Dawn from Grabalount Attorneys Inc. So Grant and Dawn, thank you so much for agreeing to do this and to help educate us all on this subject.
Thank you for having us.
Okay, so first of all, we'd assume that people know what a conveyancing attorney is, but I don't want to assume that. So can you tell us what a conveyancing attorney is and what you do?
So in simple terms, a conveyancing attorney is an attorney that specializes in property law and specializes in the transfer of property from a person who sells his house to the person who buys the house from him.
Okay, so you guys are part of that process. Okay, so today, what we're going to be covering your offer to purchase, because that's really where this process starts. We're going to look at red flags in that. We're going to look at the property transfer process and the costs. All right. Okay, so let's start with the offer to purchase. You've mentioned that that's hugely important. So I'm not going to, you guys are the experts, so I'd love you to tell us why it is as important as it is.
Okay, would you like to start?
Yes, so the offer to purchase is the beginning of a contract. That is your beginning of a transfer. That is the contract that is between the buyer and seller and dictates all the terms of what that sale is going to be. The reason why it's so important is anything that happens within the transfer has to be reduced to writing and signed by all parties. So it's not something you can change or back out of once signed, unless all parties agree. So before the offer to purchase is signed, you better make sure that everything is correct in it, from what you agree to in terms of occupational rental, from what the price is, what the deposit is there going to be a bond, is there going to be another property that's got to be sold first before you can buy that one. And this is why we advise, before you even have a look at it, to seek proper legal advice before you sign that offer to purchase.
Okay, so I've got two questions. So one, who do I get legal advice from? Because, like most of us, we'll go through our phone and go, oh yeah, she's an attorney, let me phone her. Who do I get advice from? That's my first question. And is the offer to purchase coming from the seller or the estate agent, or is that being presented to me as the buyer?
So there are many ways that it can be presented. First off, let's deal with who to get advice from.
Okay.
That would be a conveyancing attorney. So the attorney that specializes in conveyancing and property transfers. Now, the offer to purchase could come directly from the buyer. They could have their attorneys drafted up. The offer to purchase can come from a estate agent. That's more or less the case in most property transfers. Or you as the buyer and seller could agree that you want to come to an agreement to buy a property, and then you go and seek the advice of a conveyancing attorney who will assist you in drafting that contract for you.
Okay, so I think that's great to know. So I could phone you and go, hi, I want to purchase this property. Could you assist me to look through this document? Yes?
Yes, absolutely. You can phone people like us, and we can either say, okay, we'll assist you to draft the document, or we'll go over the document to see if there's any red flags or problems that you might incur.
Okay.
So that document, that contract, we usually draft free of charge to assist people to get a proper agreement in place so that it is watertight for your client, the client that comes to see you, to make sure that that transfer does actually take place at the end of the day. Because if a layperson drafts it, it might not comply with the Alienation of Land Act, which is the act governing all property sales. There are requirements in the act. For instance, the property needs to be clearly described so that you can identify it. And if that's not there, the contract's invalid. And if you don't know that it should be there, People can go along with let me say, an invalid contract, but at the end of the day, if somebody wants to renege on that contract, then he's going to say, oh, well, there's a shortcoming here because the property description isn't clear, so sorry, I'm not bound by the contract. In actual fact, he won't be.
Yes.
So that's why it's so important to get it properly drafted, and that's where the conveyancing attorney that's got the experience to know what those contracts need to comply with and what must be in the contract. That's why it's crucial to see somebody with the experience and the knowledge to do that for you.
Yeah, I mean, it's generally not a small transaction, so do it properly rather.
It's probably the biggest financial transaction that you'll ever do in your life for the average person,
Yes.
of course, because it runs in the millions most of the time.
So on that, what are some of the things that I should look out for? What are some of the basics that should be in the contract, the offer to purchase, and then some of the red flags? And maybe you can give us some examples of what you've experienced.
So the parties need to be set out clearly. What's important to know, and also somebody who doesn't have the experience wouldn't know which parties are a part of the contract. For example, a party married in community of property sells a communal home. The husband concludes the contract, he signs the contract, the buyer is happy, he buys, he signs, and tra-la-la, there they go. But the problem is, if the wife doesn't consent and also signs that agreement, the agreement is void. Now, if you don't know to do that, and there are estate agents that don't know to do that, believe me, the contract is void and there is no sale. Then everybody has gone down the line, and that's either got to be fixed with a bit of difficulty, because parties again have to agree, or the person can have buyer's remorse and decide, I don't want to buy this property anymore. Sorry, the contract's not valid because your wife didn't sign, I'm out.
So with that as well, that also applies to people that might be married out of community of property, but have been married in different countries. So in a matter like that, even though they're out of community of property by the laws of that specific country, you would still need the wife to assist, or the husband to assist in the transfer of that property. And with that, you will normally say duly assisted by. That just sort of covers all the bases, because you're not expected to know every marital law of every single country.
Yes. Okay. Red flags. What if I want to buy a property, I'm really interested, they presented the contract, I haven't been to you yet, but I'm just looking at it. What are red flags that would immediately should send off warning bells?
One of the biggest red flags, and it's something we see a lot of, especially in Gauteng, is when they don't include approved plans in the offer to purchase. That it's a requirement that the seller provides approved plans to the buyer. Generally, that means that there is a problem. They might have, got their uncle or aunt to build a garage on the property. They never got the plans approved. And now you sit with problems down the line once the property is transferred. Another one to look out for is non-refundable deposits. With that being the case, if there is a case where they try and get out of the offer and you've paid your deposit off to somebody else and not the attorney, it's very difficult to get back. Not completely lost, but very difficult to get back.
Yeah, then it involves legal action. You've got to sue to get the money back if he refuses to pay you. And people, unfortunately, the cheaper properties, people don't go and get legal advice. So they decide, okay, I'm buying this house from you. I'm going to pay you 250,000 Rand. They pay the seller the money, but the contract hasn't even been signed. There's no contract. There's no paperwork. There's nothing. And the transfer doesn't take place. And time passes, and then they realize one day, you know what, I'm not the owner of the property, but the seller's already disappeared with the money. Now you've got to start sorting those problems out. And this happens more often than you would want to know. Yes.
Okay. So one of the things I just want to bring up in terms of red flags as well is when you're buying a sectional title within a complex, make sure that you check the financials of that complex so that that the complex itself isn't so far in debt, which might cause them to have to increase levies for people. One of the transfers we've just lost, essentially, or it's fallen through, was a transfer where the complex itself has a central boiler. So each unit doesn't have their own geysers. It's a central boiler system for the whole apartment block.
Wow.
Now, that central boiler system has not been working for about a year.
So no hot water in the whole complex
In
for a
that,
year?
all those apartments have not had hot water for the whole year, and this is something that the seller did not disclose to the buyer.
Oh, wow.
Yeah, so that's why that contract fell through. And yeah.
And you also mentioned that you got to check that the body corporate finances are in order.
Yeah, that's the financials of your body corporate, because if there isn't money, so with this particular, in this particular instance, they don't have money to fix the boiler because the levies aren't being paid by the residents or the owners. So you must make sure that there's a constant flow of money coming in, so that the reserve fund is in place, because you must have a 25% reserve fund.
25% of what?
Of the income of your monthly income on your
levies.
Yes.
Okay.
So that you've got money to fix stuff like this.
Wow.
It's a requirement. I don't know. Obviously, not many body corporates or everybody does that. And if the money isn't there, you can't fix the boiler, and you don't have hot water. And this is what happens.
So another one, I mean, we do specialize in helping body corporates collect on these outstanding levies, because of course the body corporate is your first creditor.
Yes.
So before your bond, before the bank, before anything, the body corporate's levies are due first. So we help body corporates to collect these sort of outstanding levies. But we've just had one recently where the trustees of the body corporate came to us. I think there was about 350 or close to 400,000 outstanding in levies.
Sure.
And they had to raise a special levy because they were getting cut off by council. The whole complex services were getting cut off by council because they were 300,000 in debt to City of Joburg.
So the body corporate is in debt to Joburg. What? Because people were not
because there were certain people in the complex that weren't paying those levies.
And then if the debt was racked up,
they raised a special levy that all the owners had to pay. Of course, those people that hadn't been paying to begin with didn't pay the special levy. So it was all the other owners that were carrying the people that weren't paying. And another thing to look out for, and you won't find it appear in the contract itself, but make sure you check the rates account and and more specifically that rates account, the municipal valuation on the rates account. Dawn and I had one just recently now where the property sold for just over $1 million.
Yeah.
And once it transferred, the buyer found out that the property had been incorrectly valued at $2.5 million. So now all of a sudden their rates bill is double what it should have been.
That's a very interesting question. I'm sure a lot of people in the city of Johannesburg are sitting with property valuations that are inflated.
Yes.
I'm sitting in that situation. I did object, and they knocked it down a little bit, but I'm paying higher rates than I should.
And the same position?
So when it's coming to a property sale, are you suggesting look at that before you purchase the property so that you're aware of your rates and taxes?
Correct. That all comes into taking that advice before you sign that contract. Because remember, once you've signed the contract, you're locked in. Once you've signed that offer to purchase that or sale agreement or whatever they might call it, you are locked in. And you need to look at those problems. I mean, this client is now looking at about 15 to 20,000 Rand to try and sort out that issue. And we can see why the council valued it wrong. It's quite easy, the mistake they made, and why it valued it wrong. What happened essentially was they valued it at the price of all the properties sold within that street. However, this is a sectional title within a complex, and they didn't look at what all the units in that complex sold for. They looked at what all the properties on that street sold for. So it is something you can sort out, but it's going to cost you an extra 20,000 Rand, or 15 to 20,000 Rand. So something to look out for.
Okay.
And there's something else. You must make sure that you've got the money to pay for the property. We had a matter a while ago. The client thought it was a sort of a divorce settlement kind of thing. and she was expecting money from her husband to come in. He was selling one of the properties that was awarded to him in a divorce. That sale was taking longer than expected. She bought a property, put down 800,000 rand deposit on the property, and the transfer was being held up of the property that she bought because the money that had to come in from the husband's sale hadn't yet landed, and that was lagging behind because there was a problem with the bond of the buyer of that property. And eventually they pressurized her so much to pay that she says, listen, I can't do this anymore. They placed her on terms, which means you now have to pay within a certain period of time or we sue you. And she simply didn't have the money to pay. So she said, okay, I'm cancelling the contract. But now comes with this, there's a clause in your offer to purchase that says, if you are the person cancelling the contract, whether it's the buyer or the seller, you become liable for the agent's commission.
Oh, wow.
So she's the buyer and she had to pay the agent's commission. She had to settle, I think it was something like 90,000.
For property that she
didn't get because she cancelled. So make very sure there's that condition in your contract. You could put any conditions in your contract if the parties are happy to agree to it. If you don't have the money, make sure that you make provision in that contract to say, this is conditional on the receipt of X amount from that transaction. If this does not happen, the contract will be void. Then it falls through and there's no liability on either of the parties.
Sure. I mean, I think that's a lot of money to lose because you actually just didn't get advice.
Yes.
To be frank.
Absolutely. It also brings me back to the plans and making sure those plans are correct. We had a property, I think it was about 2 years ago, where when we looked at the plans, the person had sort of gone ahead and built, and in actual fact, they were encroaching on the stand next door by 30%.
Oh, wow.
And the person had just bought next door didn't realize that. And they were trying to now sell this property that was encroaching on someone else's land, and that had essentially built half a house on someone else's stand.
Land. Yeah.
And now that becomes a huge, huge liability down the line.
Yes. I mean, I see it a lot. And I've also interviewed agents and they sort of like, no, it's not in that. It's not legal that you have to furnish, that the seller has to furnish you with plans. But I always advise people, offer to purchase, ask for plans, but approve plans of what is built.
That's great.
Because very often also we see plans that are approved, but they're definitely not of what is built.
Well, I'm busy with a transfer now. So the agent wrote in the contract, building plans to be provided. So the seller, who's our client, says, well, the house is half built.
Yes.
So she's buying a shell and she's happy with that because she'll finish the building. But she wanted, the bank insisted on approved building plans to grant the bond. And then the purchaser came and she says, well, she wants the approved plans. And I said, you cannot insist on approved plans because you agreed to plans being provided. Our clients provided you with the plans up to where it has been drafted as it stands there. There was a extension that was built on that's not on the plans. So obviously it hasn't been approved. I said, well, your contract
They don't ask for approved.
Not approved plans, so sorry. If you want approved plans, you are going to have to sort this out with an architect to get those plans drafted and get it up to date, lodge it, pay for the lodgement fees at the Council of Joburg. Otherwise, you're not going to be able to buy the property. And she wants the property, so she's incurring those costs.
She's incurring the additional cost. I mean, we also recently had a project that was a renovation where guys started, and again, they needed to loan money from the bank, and the bank was like, oh, okay, so where's your approved plans for renovations? I know the bank won't pay out until they've got approved plans. Okay, that's hugely informative. Thank you very much. So, offer to purchase, hugely important because it's binding. I mean, you need to make sure that if you don't have the money, there's a way to exit. I'm assuming that there'd be various reasons why people would exit. I'm assuming the main reason would be they don't have the money. Yeah. Okay. So hugely important because that thing is binding and you can actually end up being sued or paying money to like estate agents for a property that you didn't get.
So one of the little red flags that sort of is hidden in the terms of the contract is you have to apply for a bond, X amount, and whatever the purchase price might be. Maybe it's a full bond, the whole purchase price.
Yes.
And then there's a little clause hidden in there that says that if you don't get a bond, you've got to pay in cash. I've seen contracts like that.
Wow.
So you must make very sure that there's no such clause in there, that if the bond isn't approved, that you've got to come out with the cash.
Wow.
Yeah, so we've seen that a couple of times.
I mean, that's why you'd have a bond, right?
Yes.
Because you don't have the cash.
We've seen that quite a few times, and you must be very careful of things like that. I think in terms of red flags.
I also had another contract, the agents, and these are absolutely unscrupulous agents. They go to a seller, we've got a buyer for you. And I think this was a scam, but anyway, I've got a buyer for you. Don't know whether she's pre-approved or not. So brings the contract to the seller. If you don't read the contract carefully and you sign, oh, wonderful, because you've sat with the property on the market for a long time, there's somebody to buy, you just sign. So what they did, they included a clause in that contract which said, commission is payable on signature of the agreement, which is fine, it's earned. No, it's earned on the signature of the agreement, but if the agreement falls through for any reason whatsoever, so if your buyer doesn't qualify for a bond, then you still remain as the seller liable to pay the agent's commission.
Fees.
Yes, for nothing, absolutely nothing. And the buyer couldn't get a bond. So we believe that this buyer was just a scam person.
Fake.
Yes. Because they knew that she wasn't going to get
a money-making scheme to make money. Wow.
So one of the things, just when we wrap up the red flags, not so much a red flag, but more towards the advice.
Yes.
When you're looking to sell your property and you have a bond on that property, you need to inform the bank 90 days prior to the property transferring. Otherwise, you incur cancellation penalties.
Yeah, I've heard of that. Yes.
So just even before you've gone to an agent or anything like that, just notify the bank and say, look, I intend to sell. And if you don't sell, it just continues. But just inform the bank and say, listen, I'm intending to sell the property, and then that 90 days will start to kick in from the moment you inform them.
That's super valuable advice. Thank you. Another question I had, and this comes to any defects that the building might have. So, a lot of times, and I always say this to people, when you buy a property, you buy a picture. You go in and you see this pretty, and that's what you buy. And that's why when you move in, then you look and you go, but I didn't see the damp there, or, oh my goodness, there's a massive crack here, or how does that work within offer to purchase?
So there are defects. So you get a latent defect and you get a patent defect. Defects which are visible, when you walk into a property, you can see there's a crack, you can see the floor is cracked, or the roof is leaking because there are stripes of water running down the wall, or you can obviously see damp.
Yes.
That's a patent defect because it's visible. But you get latent defects, which is not visible. And those defects, if the seller is aware of any defects such as that, they are compelled to disclose it.
So like the electricity tripping the whole time.
Because there's a leak in the wall or something. And he knows about the problem.
Yeah.
So he sort of just fixed this up quickly and had it plastered and painted, and everything looks fantastic and nice, but he knows about that problem. The issue always is, can you prove that he knew this? So if you can see that there has been recent painting and plastering and stuff, and there's a problem behind that, then it's easy to prove. But it's not always so easy to prove. So it's important to note the defects, the patent defects, of course, and that's where the property condition report helps a little bit, even though it's not a guarantee that the seller gives, to say what's contained in that report is the actual.
So a property condition report that has to be supplied by the seller.
The agent is compelled, or the seller is compelled to draft. It's a printed little thing with little blocks that says, are there cracks in your walls? Is the pool filter working? That kind of stuff. So there's a whole list. It's about 2 or 3 pages. Yes. And it's in the Property Practitioners Act. So then the seller goes, and if there's anything that he's aware of, and that is, he must be aware of something, then he's got to indicate it on this report. If he doesn't, I'm sure that you can take him for fraud, but you know, the problem with litigation in your property transfers, people want to get the property sold and registered. So if you embroil yourself in litigation, it ties the property transfer and transaction in the house up in that property litigation for a year, 2, maybe 3 or longer.
Sure.
And you don't want to do that, you see. So people are very easy to let these types of things go and then later try and sort it out if the problem is really big.
Sure.
We actually had a matter. The lady bought a property and there was damp at the bottom, which you can see he fixed up. And on the property report, he says there's mild damp. So the agent says that's mild damp, it's not a problem.
Oh, wow.
It's not a problem. So that she bought the house and they moved in, and she's got a lung problem.
Oh, wow.
So the damp affected her health. So she says, well, she doesn't want the house anymore. She wants her money back. And she's adamant. No way to fix this property. She wants the transfer reversed. And we didn't finish the litigation. We were at the time, but it's still going.
Wow.
Where she's claiming her money back, and the buyer must reverse the transfer. The seller must reverse the transfer, take the property back. Now, in the report, that says mild damp. So he knew that there was a bigger problem, and the agent actually, I think, also knew, but didn't fully disclose this to the buyer.
Sure.
So just to expound on that, that all has to relate to what people know as the footstoots clause.
Yes.
Now, those patent and latent defects, the patent defects are covered under the footstoots clause, which are defects that you can visibly see on inspection.
Okay.
Whereas the latent defects aren't covered. Those are, in layman's terms, latent defects are defects the seller knows about, but willfully doesn't disclose to the purchaser.
He hides it away.
And is there any value? I know there are people who offer like a home inspection service. Is there any value in getting, but I don't know how those people are qualified, if they're suitably qualified.
Yes, there is, if you get a reputable company who knows what they're doing and will give an honest report. So we've had a few transfers where people have come with these reports and, the house is fantastic and everything is fine. And when the buyer moves in on registration,
Not all fun.
the windows can't open or close. And it's expensive properties.
Yes.
Where the guy goes in and he sort of just glances over this and just does the report because they get a lot of money for it.
Yes.
So he gives in the report not thinking what the consequences are going to be
Down the line.
down the line. Yeah.
So I do recommend that you do something like a report, but use a reputable inspector that is licensed to do so.
Oh, okay. So
There is a license to provide home inspections.
Oh, okay.
It is costly, but it could land up saving you in the long run.
Yes. Okay. Great. So I think that was a lot of valuable information. I've learned a lot. Thank you. Should we now move on to the process?
Yes. Okay. So once the offer to purchase is signed, the conveyancing attorney or the secretary or the office of the conveyancer will contact both parties. There's paperwork to be done. So you advise the agent that you will keep them covered for commission.
Okay.
Just to make sure that they get the commission at the end of the day. Always subject to whatever legal impediments might pop up, like SARS. But the transactions we've had where tax affairs of the parties, especially the seller, has not been in order, SARS is actually quite nice about that. They will allow you to continue with the transfer and you're able to deduct your costs. So they'll be able, they authorize you to deduct the commission, any cost that you have to pay, but they want the proceeds that's left after those deductions have been made to be paid over to SARS in lieu of the tax that's outstanding. So that kind of happens. So anyway, so when all of that is signed and sorted, we apply for that transfer duty receipt from SARS. So transfer duty now is exempt up to 1,210,000 rand. So everything that you buy under that, there's no transfer duty payable, but you still have to get an exemption receipt from SARS. So
Okay.
SARS still goes and looks at the tax affairs of both the parties, and if anything is untoward, then you get a third party letter
wow.
as a conveyancer
To say,
retain.
I didn't actually know that. I didn't actually know that SARS go and look at everybody's tax affairs before
Yes.
a property is transferred.
So one of the documents you sign, it's a data sheet for SARS.
Yeah.
And it's basically how I would explain it to clients is that it's got all the parties of the seller, all the details of the seller, all the details of the purchaser, all the details of the conveyancer, and all the details of the agent. And everyone signs that sheet. Basically, SARS just wants to know all the parties involved in this transaction and essentially who's going to get paid out of it to keep themselves covered.
Yeah.
Okay, and then that's a transfer duty. Then you have to request figures, rates, clearance figures from the local authority, whichever municipality the property is located in. They give you the figures. Hopefully you get it within a reasonable time. You pay it, and then they give you the certificate, because that's got to be lodged with your transfer documents. If you are selling a sectional title property, you get a levy certificate as well to make sure that the levies are up to date.
Of the entire complex.
No, just your unit.
I was going to say,
Just your unit, because otherwise nobody is going to get transfers in sectional title developments. So you get that levy certificate. The parties sign the document. So the most important document, well, they're actually all important, but the one that we need to lodge at the deeds office, the power of attorney for the seller, signed by the seller, authorizing the conveyancer to appear and physically go and sit in front of the registrar at the deeds office and sign your transfer. So you sign as a conveyancer, and then the registrar puts his signature on there with his stamp that the transfer has been effected. Then that is the transfer has taken place. So there are other documents which we also needed, certain affidavits, especially the very important one is the insolvency affidavit from the seller or the buyer, because if either parties are insolvent, they can't act without the trustee.
Okay.
Or the insolvency practitioner that's dealing with their estate. So they have to give us an affidavit about that. They have to give us an affidavit about their marital status, because as I said previously, if you are a husband that's selling a property and you say that you're unmarried, or that you are married out of community property when you are married in community of property, and your wife doesn't know that you're selling the property, and believe me, that has also happened. I had a very sketchy transfer from another attorney once. So you get those affidavits. That actually sort of covers yourself as the conveyancer, so that if something happens down the line, or this person has acted outside his authority, or he lied, you've got the affidavits to cover yourself and say, there you see, under oath, that you are single or you are unmarried or what. So when those documents have been signed, where there's a bond, the bond will be signed. So the buyer will go to the bond attorneys. The bond attorneys will draft up their documents. They'll get that signed. If there's a cancellation of a bond on a property, because when there's a transfer, the bond must be cancelled and dealt with. So you'll have your attorney that does the transfer from the one person to the other.
Yes.
You'll get the bond attorney who deals with the bond from the bank side, and the cancellation attorneys will cancel the bond that's currently registered on the property.
Oh, wow. A lot of attorneys.
So it's 3 sets of attorneys usually.
Oh.
And we all, through correspondence or whatever,
have to communicate to get the process right.
All those documents have to be collected in one set, and it all gets lodged in one batch.
With the deeds office.
Yes. So that the deeds office cancels the bond at the same time, registers the new bond over the property, and transfers the property from the seller to the buyer.
Okay, so let me just take a step back, because you said a lot of stuff. So it's the offer to purchase. That's all signed. I'm assuming you, as the conveyancing attorney, then collate all the documentation. So it will be the affidavits, it will be the bond cancellation, bond registration. You're going to collate all of that.
We do that, yes.
You then lodge that stuff.
Yes.
And then once it's all done, you actually have to physically appear
in front of the
registrar. You sign, they stamp.
Then it's done. Then it goes to the data section at the deeds office, and they data capture the stuff so that you can get the printout
Of your title deeds.
of the details of the transfer. You can get that electronically. So if you go into Deeds Web,
I've seen that actually, yeah.
So that's why the data capturing is there, so that you've got that physical, visible data without having the actual
Title
document.
deed, yes.
But believe me, the deeds office also makes mistakes. I'm busy with sorting out something which is so, you can't believe what they've done. They data captured a different person's property details under our client's property
Oh, wow.
as a bond on the trust. So we're busy sorting that out, but it's just a matter. They must
Yes.
go and look at the documents, and they must just
Sort it
delete
out.
the incorrect data. But yes, so then the property is yours. It takes about 3-4 weeks. They physically scan the documents into electronic format now, PDF format for you, so that if your document gets lost, it's not the end of the world, because they've got
a digital
scanned.
doc.
Yes, and you can apply for it. There's a whole process, and that's a whole different subject on its own. You get a certified copy so that you can deal with your property in the future. The bank takes the original title deed if there's a bond on the property as security,
Yes.
so that you can't take the deed and go and sell the property without cancelling the bond, or without advising the bank or paying the bank.
Okay, so that's the process then.
That's pretty much the process. So
You
yes,
said 3 to 4 weeks. I thought it took a lot longer.
that's 3 to 4 weeks to get the title deed once it's registered.
Oh,
So generally,
no. How long
yeah.
does the actual
Generally,
transfer take?
we like to tell clients between 6 and 12 weeks.
Okay.
Anywhere in between. It depends on the complexity of it, but that number can vary. I mean, Dawn and I have done transfers that have taken 3 weeks.
I guess that's when everything's in order.
Absolutely, and
That's
everything's
true.
ready to
roll.
go from the OTP.
Yeah, and it's cash. Because if it's cash is paid into the trust account. We've got the money, the documents. It takes me 10 minutes to draft the documents, get them ready, print them. Then we need to see the clients. They need to sign, and if they're prepared to do it the next day, and the cash is in the trust account,
Super easy, yeah.
it's a matter of getting the figures. And incidentally, with Johannesburg, it's fantastic, because that gets issued electronically. So it takes 3 seconds for you to get the figure. If there's no engineering fees and stuff outstanding, which usually doesn't happen. So you get the figures, you pay it. It takes about a week and a half to 2 weeks for you to get the rates clearance certificate. SARS is also quite on the ball with this. So you pay your transfer duty, believe it or not, yes.
Because I want their money. Probably.
You see. So it takes about half an hour for them to issue you with that receipt. So with a cash transaction,
Much easier.
you can actually get all the stuff sorted out in about a week and a half. If you do it immediately, you lodge it. That takes about 10 days, and the property is registered.
But obviously now, if it's a bond, longer.
It takes longer, because the bond attorneys are bound by what the bank does. So the bank first has to give a proceed to those attorneys before they're allowed to lodge. And some of the banks, I shouldn't mention names, take very long to give the proceed to those attorneys.
To actually for them to start.
And
So
they
it's the bank.
simply don't care that everybody's waiting. You can wait up to 2 weeks for the bank from the time that everybody is ready to lodge the documents of deeds office. The bank can come back and after 2 weeks and say, okay, we are now consenting for the bond attorneys to lodge. And we can't lodge without them. So everything stands. And the problem with your rates clearance certificate is only valid for 60 days.
Oh, wow.
Yes. So if you don't register within 60 days of the issuing of that certificate, when they've signed it, it expires and you're going to start all over with a new. Yeah.
Wow. Okay. Wow. A lot of information. Okay. So that's our process. Now, when it comes to the costs of this process, who pays what?
Okay. So let's go over, split it between the different parties. So let's talk about the seller.
Okay.
Now, I don't think we spoke about this before, but the seller is the one who normally appoints the conveyancer. It's their duty to appoint the conveyancer. However, they don't pay the conveyancer's costs. That is something the purchaser has to pay. What the seller is liable for is the cancellation costs of their bond,
Okay.
as well as any interest or penalties on that bond.
Okay.
The rates clearance figures, as we were talking about. Now, the way the rates clearance figures work is they usually ask you to pay about 4 months upfront,
Okay.
which you pay, and even if the transfer doesn't take 4 months, you will then get a credit prorated from the date that the property transferred.
Okay.
Your next set of costs are things like your levy clearance from your body corporate. That can usually be a month or two, depending on what's really required to get the transfer done. There's also your electrical compliance.
Yeah.
So you have to get a valid electrician to come in and do an electrical compliance certificate. There's usually costs involved in that. Often, especially with older houses, there's work that has to be done because the legislation has changed and the regulations have changed as according to what is and what isn't compliant.
Yes.
With the electrical compliance, is also if you have an electric fence, you need a separate compliance for the electric fence. And if you have gas installed in the property, you'll need a gas compliance.
And depending on where you are,
Yes.
the Beetle certificates, there are certificates in the Cape. I think it's a plumbing certificate.
Oh, wow.
Yes. Various regions have different requirements, but in Johannesburg, Pretoria, and the surrounds, you don't need any of that. They don't want Beetle certificates. We apparently don't have a Beetle problem in this province.
Beetle. B-E-E-T-L.
Yes. Bore beetle.
Beetle.
You know?
Oh.
Those ones that bore
Yes.
into your rafters.
Yes.
Those ones. So you need a certificate to say that they've either been eradicated or pest control.
Oh, that you, wow.
Especially in Natal. So that's where they actually require those certificates. Yeah, but for us, it's just the fence certificate and the electrical certificate gas. Yeah, that's it. Just those three.
Yeah, so that's the costs in terms of the seller. Now, what the buyer, as well as the agent's commission, of course.
Agent's commission.
Yes.
And then very interesting that you've said that the seller appoints the conveyancer, but the buyer has to pay them. That's,
Yes.
my brain is like, what?
So essentially, you are, as the transferring attorney, you become the seller's attorney, and the buyer then pays the costs and everything involved in the transfer. It helps you be a little bit more, I'll say, unbiased towards either of the parties.
Because the buyer has to pay you.
Correct.
Okay.
So, and at the end of the day, you are giving effect to the contract, and that helps with that. Now, in terms of those buyer's costs, it's obviously paying the conveyancer's fees, which there are a number of fees. Those fees are tariffed by the Legal Practice Council.
Okay.
So they decide what it is a conveyancer were to charge, depending on the price of the property. Also, depending on the price of the property, on a scale is your transfer duty.
Okay. It's also obviously on a scale.
And currently it's been above 1.1 million. But with the new budget, I think they've proposed that is increased now to 1.2 million. And I don't believe that's something that's been disputed. So if anything, that's a help. It's a tax save for everyone. And that in terms of buyer's costs, that's about it.
I mean, obviously the buyer, but this is not within your remit, also is going to incur bond registration fees if they're taking a bond.
Those are part of the transfer costs because they'll have to pay the bond attorneys. The bond attorneys are appointed by the bank.
Okay.
So whichever bank you get your bond through, they will have a panel of attorneys that they appoint.
Okay. And then just a question. So the conveyancing fees and the transfer duty, when are those payable?
So those are payable on demand from the conveyancer. One thing you must remember about transfer duty, it has to be paid within 6 months of the offer to purchase being signed. Otherwise, there's penalties over that that the buyer has to pay on that transfer duty.
Okay.
Yeah, so even if there's a dispute on the validity of anything in that contract,
still has to get paid.
You have to pay, otherwise SARS comes back. So those problems are not our problems. That's something you need to sort out.
Even if what if, like your lady, you used this example earlier, she didn't have the money, so she had to pay the agent's fees, but then did she still have to pay?
No.
No.
So if the contract doesn't proceed,
Then
you're not
not.
liable for the transfer.
It's just if there's an issue and it's dragging out.
Yes.
Okay.
But so if there's a problem, you pay the transfer duty if you see it's going to go past 6 months, but you pay it the last day, obviously.
Yes, okay.
And if you can't get the problem sorted out, the contract gets voided because of that, then you have to go into a refund process with SARS. And SARS says, we're going to sort this out within a couple of days, but don't you believe me?
Yeah.
It takes
Hurry up and
months.
wait.
But they do refund you at the end of the day because the transfer didn't take place.
So they can't tax you on something that didn't
That
happen.
didn't happen, no.
Okay, sure. All right. So we've spoken about the cost and who pays what. And there's a transfer duty. Are there any other costs that one should know about?
Yes. So we've spoken about transfer duty, and that's your main way of transferring a property. However, not every property transfer is reliant on, you have to pay transfer duty on. A lot of them are VAT applicable. So this happens when the seller is a VAT vendor.
Okay.
Then the property will be a VAT transfer. So no transfer duty, but VAT applicable.
Okay.
So it's important to note in the offer to purchase whether the property is VAT inclusive, whether the purchase price is VAT inclusive or exclusive. So if you look at a property that the agent says, okay, it's VAT exclusive, now all of a sudden the buyer has a look at it, gets it, has to pay that VAT on top of the purchase price.
No.
Or what's happened as well is the seller might think they're going to be getting, let's say, 10 million for their property. But hang on, they're going to take the VAT off because it was VAT inclusive and they didn't realize.
Oh, wow. Okay.
So in that respect, the buyer is, winning. And so that needs to be discussed well before, and you need to know who the parties of the contract are.
And is a VAT, so like is a property that is a VAT, I don't know how you word this properly, where VAT is due, is that because it's owned by a business or a person that is VAT registered?
Correct. So they would be a VAT vendor. The person that owns the property, who's on the title of that property, is a VAT vendor.
Oh, wow.
And that is generally when it is. You do have instances where it is, say, a sale of a business.
Yes.
Say like a hotel or a guest house or something that is going to be utilized for those purposes. You have the option to apply to SARS to request that it's zero rated, because that would be a sale from a VAT vendor to a VAT vendor. So SARS says, okay, well, that person's going to claim the VAT back, that person's going to pay the VAT in, so we might as well just zero rate at that point. But it has to come, SARS has to give you permission to do so.
Okay, but it's a good thing to know.
Yes.
Yes, it's a good thing to look out for. Sure, okay. Are there any other tax implications?
Yes, so we talk about
more.
Yes, so we talk about capital gains tax.
Okay.
And although we don't specialize in tax ourselves, and it's always good to talk to your tax consultant about stuff like this. I can just give you a brief outline in terms of what is capital gains tax implications on primary residence and secondary residence.
I thought there wasn't any on the primary.
So primary residence gives you a 2 million rand cap on your capital gains tax. So if, for instance, you sell your property you buy your property for 5 million, you then sell it for 10 million. You get 2 million, you made 5 million, but you get 2 million of that.
So you're getting taxed on 3 million?
So you're getting capital gains tax on the 3 million.
I'm a little bit disgusted.
So
it's just tax on everything.
SARS will find a way. And so that primary residence, you as a taxpayer, you're allowed to transfer one primary tax residence within each tax year. Within one tax year, you're allowed one primary residence.
Okay.
Now, that is the residence that you live from and you're not deriving any income from.
So hold on, you need to take a step back here. So you say that 2 million is exempt.
Yes.
So let's say you're now selling the property for 2.2 million.
It depends what you bought it for.
Oh,
So the 2 million is on the profit that you've made on the property.
okay. So it's 2 million profit.
Yeah.
Okay. Now this blonde is with the program. All right. Sorry. Continue.
So with a primary residence, it's a property that you live in and don't derive any income from.
Okay.
A secondary residence, that might be a holiday home, an investment property you might own, or something like that. Now, with a secondary residence, there is no sort of cap that they give you, exemption they give you.
So it's just
So you get the
sale
capital
value.
gains tax. This is why it's important for when you buy a property, and especially when you buy a property that you do serious renovations to keep all of those invoices and that, because that'll come against that capital gains tax.
Wow.
So it's important right from even if it was 20 years ago.
I didn't know that.
Any money that you've spent on renovating the property, so
As well as your transfer fees.
as well as your transfer fees that you've paid.
Wow.
Just keep those documents.
Okay.
So those documents you must all keep with you, so that can go against that capital gains tax
As an expense.
as an
Makes
expense,
sense.
and your tax accountant or whatever will be able to collate that and at the end of the tax year give that to SARS. Because remember, that tax will not be due now. That capital
Yes.
gains tax will not be due now.
It's in that tax
It'll be
year.
within the tax year. So you might get through the transfer. You think, oh, all's peachy, and then SARS says, hang on, but you sold this
You owe
property.
us.
You owe us capital gains
However
tax on this.
money.
And they know what you bought it for, and they know what you sold it for. Another one is now with a foreigner who might own a property here that sells the property.
Yeah.
There's a thing called withholding tax. So this is where they tell the conveyancer to withhold, I think it's 7.5% of the purchase price, withhold that, so that if that buyer goes overseas, they know that that money's sitting there until they've paid the capital gains.
Okay. So okay. And then what? Did they get refunded?
They get
Once
refunded,
they
whatever,
paid their
it
tax?
all gets calculated and they
Withholding
get
tax.
refunded. Yeah.
Okay.
That is only with sellers that are foreign nationals.
Okay. Wow. Okay. So there's actually, I've learned a lot. Thank you very much. There is a lot of costs that you have to plan for. Now, is there any way that you can save money? I mean, is that something? So, I mean, it's super interesting. I mean, the fact that the seller must appoint, actually, that's a great question. So what if I'm a buyer and I want to appoint my conveyancing attorney because I've worked with them before and they've saved me money?
Yes. So, as I said, it is usually the prerogative of the seller.
Yes.
However, it comes once again down to that contract.
Yes.
If the buyer specifically
Insists.
states in the contract, it is a condition of the sale that my conveyancer is the one that handles the transfer.
Yes.
Then, and both parties agree to that, then the buyer can use their conveyancer.
Okay.
With regards to trying to save on that, this is why I say it's important to seek that advice from a conveyancer, because there are many ways that a sale can be structured,
To save money. Yes.
either to save money or to make things easier or to save time, or there might be certain ways. Say you've got a tenant that wants to buy a property from you, but they want to buy it over a period of a year or 2 years. There are certain ways to structure that they can pay on a monthly basis.
Okay.
And those are different ways to structure that. Say there's someone who's looking to buy your property, but they want the furnishings or your custom-made curtains included.
Whatever. Then you
There are
can
ways to
structure
structure the sale of that property correctly.
So those costs for that part of the contract will normally fall outside the purchase price because it's not the property. It's not
Okay.
the property that you're
Yeah.
buying. It's the furniture and the other stuff that you include, which is not part of your sale agreement. There's a separate agreement that regulates that.
Okay.
Yes.
Makes sense.
And it all comes down to seeking the advice of a conveyancer. One thing I can tell you also about conveyancers, it's not like a conveyancer is stuck to one area.
Yes.
They work within the entire Republic of South Africa. So conveyancers will handle transfers that are in Conveyancers in Joburg will handle transfers in Cape Town, in Durban, in wherever it may be. So it's important to find someone that you can trust.
Yes.
As I said, because it's your it's generally going to be the biggest asset that you're going to either purchase or sell. So it's important to garner that information beforehand from someone that knows what they're doing.
Yes.
There are certain conveyancers and attorneys, like our firm, we will provide advice like that for free, because we know we generally then will do the transfer.
Yes.
Some will ask for a consultation fee. That is just all depending on who.
I mean, it's incredible. Like we work in the property field, but today is the first time I've actually learned how important a good conveyancing attorney is to have in your deal. And I hope that anybody who watches our video has the same. I do have one last question. Maybe, I don't know how many last questions am I allowed, but something that I have here in my notes that I see I don't think I asked you is there a difference when I transfer land, vacant land, and a building? Because obviously we're involved in build. Sometimes we do renovations, sometimes it's new builds, but I actually, besides the fact that you pay higher rates when the land is empty, I don't really know much about, is there a difference in the transfer process?
No, actually not. It would, however, be an issue with costs. If vacant land hasn't been serviced,
yes,
then you've got those additional costs. Where if you've got a property on the land, already a house, the services should already be included. So, but the process isn't any different. So the transferring process, you still have an offer to purchase. In that offer to purchase, there are certain conditions that you must make sure is in there. You must make sure that the property is zoned for what you want it to use it.
Yes.
Otherwise, you've got that problem to still go and apply for zoning. And if you don't have a condition in your offer to purchase to say that if I can't get the zoning for
then we're not going ahead.
Then the property, the deal falls through. Because now you sit with a property, if you want to build a hotel on there or a school or something, and this happens very often, people are now all going into private schooling. So they're buying land to build schools, and then the council doesn't want to give them zoning for that particular thing, and they sit with that land, and then they need to be inventive to try and sell it to somebody else if they can't do anything with it. So from that point of view, that's what is required, but for the transfer process,
because I mean zoning, I know that the zoning just, it's like a swear word to change zoning anytime planning. I don't know in other provinces, but or other places, I specifically know in Johannesburg, get ready, hurry up and wait.
Yes.
Yes, it's going to take time.
Yeah.
Okay, so the process is exactly the same, just make sure. I mean, we've covered a lot. I don't know if there is anything else that you'd like to say or give advice to people, in terms of the property transfer process when we're buying a property. Any last words?
So, once again, I just want to reiterate, the best advice we can give is seek advice.
Okay.
Yeah, absolutely. Absolutely, because that contract locks you in. It really locks you in. We can try and get you out, but it's not easy.
It's not easy, and it's going to come with cost.
Yes.
Okay, thank you very much. This has been super, super informative. We will obviously put your details in the bottom of the video, and then if people want to reach out to you, they can.
Thank you. Thank you for having us.
Thank you.
Thank you so much.